Hello, good evening. Please join me in welcoming Charles Gordon, who's going to give a presentation to us this evening on business interruption insurance, the test case that is currently in the English courts and indeed will be going to the Supreme Court on Monday. Charles is a solicitor, a mediator and an arbitrator, and he's handled a huge number of disputes from all areas, including insurance and reinsurance, negligence cases, property, shareholder disputes, joint venture disputes. And he's covered it from all angles, representing parties on both sides, but also in his capacity as mediator, arbitrator, from the bench, so to speak. He has also been a long-standing supporter and visiting lecturer at Queen Mary. And he usually gives presentations on the trigger litigation, domestic cases. But this year, very topical, the business interruption and COVID-19 insurance case. So just by way of housekeeping, this session is being recorded. There is going to be a Q&A session at the end. Charles figures he'll be talking for about 45 minutes to an hour. If you have any questions that occur to you whilst he's speaking, can I suggest that you maybe put them into the chat or save them for a live discussion at the end? So thank you very much. And then without any further delay, Charles, welcome and over to you.
Thank you very much, Francisca, and good evening, everybody. Thank you for joining us for this session. So as Francisca said, we're going to be talking about business interruption insurance, and in particular the test case which has been going through the English courts to determine how certain business interruption policies should be responding to the COVID-19 pandemic. As Francisca said, I've spent many years in my career working in relation to insurance and reinsurance disputes, and I always used to find that cases involving business interruption insurance are the most difficult to resolve. And the reason for that is pretty clear. When you have damage to property, physical damage to property, to buildings, to factories, and so on, the process of valuing the loss which the insured has suffered isn't always straightforward, but it is clear parameters. You are placing a value on the property that has been damaged, and you can use external valuers and processes and so on to arrive at a value for the property that has been damaged and which is covered by insurance. By definition, business interruption losses are not looking at the past, they're not looking at something concrete, they're looking at the future, because the basis of the insurance is obviously that the insured's business has been interrupted or damaged or disrupted by, in most cases, and we'll come on to the exceptions to that, which this case is all about, but in most cases triggered by some damage to physical property. So there's been a fire, there's been a flood, there's been an earthquake, there's been a hurricane, which has damaged the insured's property. And what you are doing with business interruption is looking into the future and determining over the period that the insurance is covering what loss and damage has been caused to the insured's business by the insured event, by the hurricane or the earthquake or whatever it may be. And so, of course, you're having to make an educated guess as to what the business would have achieved during the period of the interruption, and comparing that with what is now going to happen in light of the damage to the property. So it carries with it a lot of issues and difficulties, because you are, to an extent, trying to use a crystal ball and to look into the future. Could we have the next slide, please?
Sorry, I seem to be stuck here.
That's okay.
Um,
Well, while we're just waiting for the
sorry.
to come up, I'll just give you a little bit of background to the case that we're talking about. It's probably one of the most, thank you very, that's going just
Sorry.
one back. It's probably one of the most important cases to have gone through the English courts in relation to insurance for many years, partly because of the amount of money involved, and partly because of the issues that are raised by the case. The background is that following the beginning of the pandemic and the various actions that were taken by the government, a lot of insureds started looking at their ability to make recovery under their insurance policies. And although the traditional form of business interruption policy relates to losses triggered by some physical damage to property, it has been possible for many years to buy extensions to insurance policies whereby you can claim business interruption losses triggered by an insured event, which doesn't have to be damage to your physical damage to your property. We'll come on right at the end because there's been another quite recent case which has looked at whether traditional business interruption policies requiring physical damage to property might in some way be triggered by the COVID pandemic. But what we're concerned with here is those extensions to business interruption policies which allow you to claim for business interruption, but where there has been no physical damage to property. So this case was brought by the UK's Financial Conduct Authority, which is the regulator of the insurance industry, and they used a not very frequently utilised mechanism called the Financial Markets Test Case Scheme, which enables the FCA to bring a case essentially on behalf of policyholders generally, where they think there's an issue that is much better resolved by a test case than it would be by a series of individual cases. We all know that test cases and group litigation are complicated mechanisms and expensive mechanisms to bring before the court. So this test case scheme is a way of bringing to the court an issue which affects a wide body of policyholders and a wide body of insurers. And here the need was to resolve the uncertainty in the interpretation of these business interruption policies in the context of a COVID-19 pandemic. Because of course, thankfully, these type of pandemics, these type of global, national and global events don't come along very often. And insurance policies perhaps haven't traditionally been designed to respond in a clear-cut way to these type of national or global events. So in the litigation, the Financial Conduct Authority essentially has represented the policyholders collectively, although in fact two action groups which had been founded to represent different groups of policyholders, they were also given permission to join the litigation. But essentially, the case was run by the Financial Conduct Authority. 8 insurers were chosen effectively to represent the different types of policy wording that were relevant to the case. So we had 8 different insurers, and just for your interest, those 8 insurers, I haven't put them on the screen, but they were Arch Insurance, Argenta, Ecclesiastical, Hiscox, Amlin, QBE, Royal & Son Alliance, and Zurich. So those 8 insurers agreed to participate in the litigation, and there were a total of 21 sample policy wordings that were brought before the court, each to be interpreted individually on the basis that these represented a cross-section. And it was thought that they represented over 700 different types of policy. 60 insurers were involved behind these 8 who were the representative insurers. And there were about 370,000 UK-based policyholders who were potentially to be affected by the test case, who had insurance policies that might potentially respond to the losses suffered as a result of the COVID-19 pandemic. And the estimate is that the potential for claims could amount to over £1.2 billion in insured losses. So a very sizable case, and of interest widely within the UK insurance industry, but also more widely than that, because other common law jurisdictions, particularly Australia, Canada, New Zealand, and various other jurisdictions, are following this test case very closely and have test cases of their own, which will be highly influenced by the outcome of this particular case. So this led to, we'll come on to in a moment, a trial which lasted 8 days in July in the High Court in front of 2 judges, a judgment that was given in September, and as Francisca said, an appeal going directly to the Supreme Court, leapfrogging over the Court of Appeal because it was certified to be a case of sufficient public importance to go straight to the Supreme Court, that hearing taking place next week. So in legal terms, the case has gone extremely fast. There will probably be a judgment from the Supreme Court before the end of the year. And given that the case didn't start until the early part of the summer, to get the case right through the legal system in that space of time is pretty remarkable, and a testament to the importance which is attached to the case. Next slide, please. So I've mentioned a bit already about what business interruption insurance is. It covers loss of profits and additional expenses, usually arising from insured physical damage to property of the types we've already talked about: fire and flood and storm and earthquake, etc. Many policies then, and these are the ones in issue in the case, also extended cover to non-damage business interruption loss, where the insured has not suffered physical damage but has suffered a clear financial loss arising from a specified event or situation. And so it is the non-damage business interruption which is the issue that the case is dealing with. Next slide, please. So, as I've said, these non-damage business interruption insurances are usually written as extensions to policies. So in other words, the insured has the option to choose to add on this area of coverage to their more traditional business interruption insurance, which would be linked to physical damage. And as with all liability insurance, what you're looking at is to establish what is the trigger for coverage to apply to any particular situation. And what was decided for the purpose of this case was that you were really looking at 3 common extensions to cover, which provide cover for this non-damage business interruption. The first is what is traditionally called denial or prevention of access. So what you're looking at here is a situation where a business finds itself unable to operate from its insured premises as a result of some government or other public authority action. So sometimes that may be in the context of a disease, but it might be in the context of some form of civil unrest or something of that kind, where particular areas or particular buildings are closed as a result of government action. And you can see how that arises in the context of the COVID cover. So that's one type of cover. The second is where a notifiable disease has occurred, and by notifiable disease we mean some disease that is recognized by the public health authorities as a particularly serious, usually, or in fact almost invariably, an infectious disease which requires public authority action in order to contain the spread of that disease. So you're looking there at a notifiable disease which has occurred at or within a specified radius of the insured property. And just pausing there for a moment, you can see immediately the kind of controversy that has arisen as far as insurance coverage is concerned, because particularly that second category of cover carries with it the connotation that what you're looking at is something that has occurred in a local area, in a small area. Maybe there's been an outbreak of a particular disease, infectious disease, in a small area. Maybe there's been some food poisoning occurring, some contamination occurring in a particular area, which would be the traditional kind of trigger for these sort of extensions of cover. Of course, what we're dealing with the COVID pandemic is a very, very different scenario, where the national authorities have responded to disease which has found itself breaking out throughout the country and have taken action in relation to national events rather than local events. And we'll come on to the significance of that. And the third category are sort of hybrid wordings, which are triggered specifically by restrictions that are imposed on the use of premises following the outbreak of a notifiable disease. So what the court was looking at was, in very detailed terms, looking at these three different types of policy wording and determining how they should be treated as responding to the COVID pandemic. Next slide, please.
Back again.
Thank you.
Sorry, it's stuck again. Here we go.
Don't worry. So just again, setting this in context, looking at how business interruption losses are quantified rather. First of all, the insurance policy will specify the period for which you are entitled to cover. Now, that might be, occasionally it'll be longer than this, but usually the maximum period of cover would be 12 months. Occasionally you'll get 24 months coverage for big insureds who might suffer very significant loss. Quite often less than 12 months. You might get 6 months coverage of losses flowing, business interruption losses flowing from a specified event. And what the insured has to do is find a way of quantifying what their loss of profits and additional expenses are that have been caused by the insured event. And normally the policies have a mechanism for taking the previous 12 months, the 12 months leading up to the insured event, and taking that as the benchmark against which you judge what the business would have done in the following year. And then it will be for the insured to adjust that in making their claim, to take into account what might well have been likely to have happened in the subsequent 12 months. So this is where, as I said at the beginning, there's a certain amount of crystal ball gazing. So for example, if you ran a hotel and you had a very serious fire, which substantially damaged the hotel or put it out of business, but in fact you were planning an extension to the hotel, which would have come on stream during the period covered by the business interruption policy. So in that case, you would be saying, well, of course, my loss needs to be adjusted based not just on what the business did in the previous 12 months, but to take into account the changes in the business that were going to take place in the following 12 months. So all those sort of issues can be taken into account by the insured, and then the insurer will have to, with the assistance of loss adjusters and so forth, determine what the loss of profit and additional expenses would have likely been in the 12 months or whatever period it is following from the insured loss. And many of these policies include what's called a trends clause, and that is to determine the trend of the business and to make adjustments to reflect what the trend of the business was in the period leading up to the insured loss, and therefore what it would look like in the future. So if the business was suffering a reduction in turnover in the previous 12 months, so that the turnover was gradually showing a reduction, then of course the insurers would be saying, well, that's got to be extrapolated forward to look at what the losses, the profits would have likely been in the subsequent 12 months. And you can look not just at the insured's own business, but you can look at prevailing market conditions and determine how those market conditions might have affected the business going forward. You can't simply come up with speculative ideas about what might have happened to the stock market or the economy or taxation rates or that sort of thing. It's got to be based on firm evidence, but many of the cases I dealt with over many years did require just that kind of adjustment. I had a case a few years back relating to the mining industry in Australia and the coal mining industry. And one of the major issues was what was going to be the price of coal over the 12 months after the insured event, which in that case was flooding, very serious flooding in the coal mines, which put them out of operation for several months. And there was a huge controversy as to whether the coal price was likely to go up or go down or stay the same during the subsequent period. So that's why these policies would normally have some kind of trends clause in them to allow you to make adjustments for the trend of the business. And we'll see how that became relevant and is relevant in the context of this particular test case and the claims that have arisen following the COVID-19 pandemic. Could I have the next slide, please, Francisca? Thank you. So let's look at a few of the background facts. I mean, we all sadly know far more than we'd want to know about COVID-19 and its impact on our lives and the places where we live and our families and so forth. But what this case had to focus on was the trigger for cover under the various insurance policies, because as I've already explained, these policies have to be triggered by an event, and that will be determined by whether it's one of those disease policies that's triggered by a notifiable disease, whether it's triggered by some hindrance or prevention of access, or some sort of hybrid version. So the court was looking at the key events that took place in the UK. Obviously, similar things happened in many other countries around the world. And the key dates that the court here had to focus on were the dates in March of this year, when the government started taking serious action. Many people said it was a bit late off the block, but we don't have to go into that for tonight. But on the 3rd of March, the UK government announced its COVID action plan. On the 5th of March, COVID-19 became a notifiable disease in England and Wales. So for those policies that were triggered by the declaration of a notifiable disease, the 5th of March was a significant date. On the 11th of March, the World Health Organization declared that COVID-19 was to be treated as a pandemic. And on the 16th of March, and many of us will remember this, which is when the Prime Minister came on television to essentially tell us to stay at home, to avoid non-essential conduct and travel, to work from home, and to avoid social venues. So that was the beginning of the first lockdown, and a significant event. But on the slide, you'll see that I put the word directs in inverted commas, because although that was essentially a direction from the Prime Minister to all of us to conduct ourselves in certain ways, it wasn't actually a change in the law. And if we could have the next slide, please, you'll see that the government then moved over the subsequent days to introducing legal restrictions on people's activities. And on the 20th of March, the government directed certain categories of business to close, including pubs, restaurants, gyms, etc. And this was given effect, legal effect, by regulations which came into force the next day, the 21st of March. And then on the 23rd of March, the government announced the lockdown involving the closure of further businesses, including all non-essential shops, restrictions on individual movement and so forth. And those directions were given legal effect by further statutory regulations on the 26th of March. And again, of course, it's obvious that not all the steps taken by the government, by the UK government, impacted all policyholders equally or in the same way. The 16th of March statements that I've referred to did apply to everybody. They were across the board, but they were by definition general. But when you get to the later part of March, you get the regulations of the 21st and 26th March, which, as regulations always are, were much more focused and precise as to whom they had an impact on. And of course, they did become law, and therefore consequences flowed to those who did not comply with those regulations in terms of the potential for fines and criminal convictions and so forth. So that's the background. If we could go on to the next slide, please. Let's look at what the case was about. I mean, I can sum it up really by saying that what the Financial Conduct Authority was arguing on behalf of policyholders was, look, this is a global pandemic. It's certainly a national pandemic as far as the United Kingdom is concerned. And insurance policies that provide business interruption insurance that can be triggered by notifiable diseases or impacts on people's ability to use their premises for business purposes, those policies should all be responding to this event, and they should be agreeing to indemnify insureds for whatever period of cover they've got based on the normal way in which business interruption insurance is triggered. So they wanted to look at it in a very holistic way, not descending into too much detail on the individual policy wordings, but simply seeing the way the insurance industry should respond as being a sort of collective coverage for those who had the necessary policies. Insurers argued, on the other hand, that business interruption policies of this kind were never intended to cover something like a global pandemic. These policies were designed to respond to local incidents, local events, local lockdowns caused by some local outbreak of disease or some local incident which caused the authorities to close areas or particular buildings, and not the consequences of a national event. And the insurers pointed out, as they always do, that the way they priced these policies, the way they determined the premium, was not on the basis of the potential for every several years large national events to take place. It was very much on the basis of looking at the risk involved of local incidents taking place. These type of insurance covers were not, as I understand it, particularly expensive from a premium point of view. They were also usually the limit of cover, the maximum amount that you could claim, was usually relatively small, often only in the tens of thousands for individual businesses. Again, not really from the insurer's perspective, indicating an intention to cover some long-term national pandemic of the kind we were faced with here. The Financial Conduct Authority response to this was to say, well, look, if insurers wanted to exclude pandemics, there would have been nothing to stop them writing in an express exclusion in their policies for that particular type of event, and they didn't do that. That's an easy argument to make when you're acting on behalf of an insured, but it's always met with the fact that, with the response that these are what are called named perils insurance policies. They are not all risks insurance policies, and all risks insurance policy, as it says on the tin, responds to all risks unless they are expressly excluded. whereas a named perils policy, which is the type of policy we're dealing with here, responds only to the perils which are named in the policy and not to anything else. So it boiled down to the FCA arguing for a very broad interpretation of the policy wording, and insurers wanting the key clauses to be interpreted as narrow as possible. And that wouldn't be the first time that's been the battleground in insurance policy wording disputes. Next slide, please. So if we look on to what actually happened in the court, it makes for fascinating reading. And if you ever have time or the inclination, the judgment is readily available online. It's a pretty substantial document, but I think, as I said at the beginning, it is a case that really does bring out many of the most important and fundamental principles of English insurance law, and the way in which liability policies, damage policies rather, should respond to events of this kind. It was the result of the case was treated in sort of press coverage as being a victory for the insureds, for the policyholders, and overall you could probably say it was a victory for the policyholders, but the devil is in the detail, and because the court was looking at a whole range of different policies, the outcome varied quite considerably from one policy wording to another. And as we'll see as we go through, some insureds found themselves without cover simply because they had been sold a wording that has turned out to be more narrowly focused than other types of wording. And so in particular, most, if not quite all, but most of the disease wordings and the hybrid wordings were found to provide cover in respect to the COVID-19 pandemic, and some of the prevention of access wordings were also found to provide cover. The key finding that was in favour of the insureds was the court's finding that you could not make a distinction between local responses to the pandemic and the overall pandemic itself. And you couldn't make a distinction between the impact of government regulations and laws and the overall impact of the virus, because the insurer's principal argument was, well, it's all very well to say that X, Y, and Z business has suffered a financial loss as a result of the government's decision to close down pubs and restaurants and so forth. But, so the insurers said, that business would have suffered pretty much the same loss even if the government hadn't directed those closures, simply because of the overall effect of the pandemic itself, because the overall effect of the pandemic itself was that everybody basically decided they needed to stay at home, not go to restaurants, not go to work, not travel on public transport and so forth, and therefore businesses would have suffered very significant losses of turnover, even if the government hadn't made the pronouncements that they made. Now, the court, I think quite rightly, gave pretty short shrift to that argument from the insurers and basically said you can't carve up the pandemic from the responses to the pandemic. And so provided an insurance policy has actually been triggered by an event that is covered by the policy, the insured is entitled to recover for all their losses flowing from the impact of the virus. They don't have to narrowly determine which losses flowed from the government's actions and which losses were simply because of the overall economic collapse caused by the virus. They don't have to make that artificial distinction. The proximate cause of the business interruption was the peril, the composite peril of that business interruption following the occurrence of the notifiable disease, and individual outbreaks form an indivisible part of the overall pandemic. So that was definitely a success for insureds across the board, and was one of the principal planks of the insurers' argument. But it didn't go all the policyholders' way, as we'll see if we could go on to the next slide, please. So if you take this concept of prevention of access, it's a strange one really, because prevention of access carries with it a sort of idea that somebody boards up your premises, that there's an armed guard standing outside your restaurant or your factory or your office, physically preventing you from entering the premises. And some of the insurers certainly argued that that's what prevention of access means and required. What the court said was that there are 4 component parts to triggering an insurance policy which is based on prevention of access. There's got to be an incident which causes a competent authority, i.e. a public authority, whether it's a local, regional or national authority, to take some action which prevents access to the insured's business premises. And the court interpreted incident quite narrowly, so that you do need to get trigger under your policy. You do need to be able to point to a local incident, an effect on you locally, and the restrictions which have been imposed in response to that local incident. So what that meant was, and this may be a relatively straightforward thing to do ultimately, is that every insured is going to have to demonstrate, the insurers may not take this point when it comes to adjusting individual claims, but technically they can take it, that the insurer will have to demonstrate that there actually were local outbreaks in their area. You can't just say, oh, well, there was a national pandemic, therefore my policy is triggered. You do have to show that there were local outbreaks in your area. Now, I think that probably covers the entire United Kingdom. But if the insurers were able to demonstrate an area where, for whatever reason, because of its isolation, there had literally been no outbreaks, then cover that was based on notifiable diseases might well not be triggered. But I suspect in practice that's not going to be a major issue. But that's how prevention of access covers are now required to be triggered as a result of the judgment. If we could have the next slide, please. Now, this was an area where the insureds didn't do quite so well, because although the FCA argued that original statement by the Prime Minister when he spoke to us all on the 16th of March and directed us all to stay at home, the FCA argued that effectively was a legal direction, because it was given to us by the government, and it wasn't in terms of advice, it was in terms of a requirement. But from the court's perspective, that wasn't sufficient to trigger these policies, because it was theoretically open to people to ignore that order without any legal consequences, because it hadn't at that point been turned into law. So those statements were purely advisory, and wordings which require actions or orders which are imposed require steps with the force of law. And so those policies would only be triggered from the date on which laws and regulations were introduced that required actions to take place. And then again, looking at this concept of prevention of access, there was a lot of debate in the case about whether that could only be triggered if a business was completely closed down and had no possibility of opening or operating at all. And the courts did say that the phrase inability to use premises does mean what it says. Simply some sort of hindrance or restriction of use is not enough. And prevention of access does mean impossibility. There must have been a closure of the business, or at least a fundamental change in the use of the business. Now, many business activities cause issues with these definitions. The classic one, of course, is a restaurant. if you were running a restaurant that only served customers in the restaurant itself and you had no takeaway element to your business and you were required to close by government direction, then your policy would likely be triggered as a result of this judgment, because you were, although not physically prevented from entering your building, you were prevented from operating your business from your building as a result of government regulation. And so that would be sufficient to trigger. But if you had a thriving takeaway business alongside your sit-in restaurant, you may well find yourself unable to claim because your business has not been closed. It has been affected, but it hasn't been closed as a result of the government action. So there will be quite a lot of debate, particularly from businesses for whom takeaway activity was a very small part of their operation, possibly just an incidental part of their operation. They will argue, and they will probably be successful, that they can still claim under their policies. But a business that had a very substantial takeaway element, to a restaurant business that had a very substantial takeaway element, may well find itself unable to claim under these type of business interruption policies because they weren't prevented from using their business premises. They were affected, but not in a way that would trigger cover under their policy. And you can think of many other examples. You can think of office premises where, although offices were physically required to close, most businesses were able to continue operating with people working from home. And so again, those businesses may well find it difficult to claim under these type of policies because although they were prevented from access to certain premises, they weren't prevented from operating their businesses, although they may still have suffered a significant reduction in business turnover. So next slide, please. Disease clauses, as I've said, they fared pretty well because the court determined that they were triggered by the national response to the widespread outbreak of this disease. And so the cover was not limited to outbreaks wholly within the defined area in the policy, whether it be a mile or several miles or whatever. Many of these policies had a physical area written into them in terms of where the notifiable disease needed to be. The courts determined that it's sufficient if there's a national disease that effectively, a national pandemic that effectively covers the entire country. There's a lot more detail, but obviously I'm not going to go into all of it tonight. It's not particularly interesting or relevant to look at all the individual points, but I'm happy to take up any individual points that people may have if there are any questions later. From my point of view, one of the most interesting things is what the court said about these trends clause that I mentioned earlier. And a lot of discussion took place in the court hearing about a case called Orient Hotels and Generali. Generali being an insurance company, Orient Hotels obviously being a hotel group. And that was a case that arose out of damage to a hotel in New Orleans in the United States following Hurricane Katrina in 2005. And in that case, the insured's hotel was damaged, very substantially damaged by Hurricane Katrina. And they tried to claim on their business interruption policy. Now, the case went to arbitration initially because there was an arbitration clause within the insurance policy. And the arbitrators had a look at the wording and had a look at the situation, and they decided that, in fact, Orient Hotels could not claim under their policy because even if the damage had not occurred to the hotel, New Orleans was closed as a city as a result of the effect of Hurricane Katrina, and therefore the hotel would have had no business anyway. So in what was widely perceived as quite a harsh judgment from the perspective of the policyholder, the court determined that the business interruption policy in that case did not respond because the business would have been closed. And using that trend clause, when you look at what would have happened to the business but for the insured event being the damage, the physical damage to the property, and the court, the arbitration tribunal determined that it would have suffered the very same loss of business because the city was closed. Now, that case, as I said, was decided by arbitrators, but it did go on appeal to the commercial court in London, and the commercial court upheld the decision of the arbitrators and upheld the decision to the effect that the insured could not make any recovery following the impact of Hurricane Katrina. And so, of course, in this case, the insurers argued that the very same principles should apply to the COVID-19 pandemic. Never mind that there was a notifiable disease, never mind you were prevented from access to your business would have substantially suffered a downturn in turnover as a result of the overall impact of the pandemic on the community. So that argument was run very strongly by insurers without success as far as the case in the first instance decision was concerned. We'll see what the Supreme Court make of it when they look at it next week. But that was the decision which was made by the High Court. And although they didn't have to, as it were, overrule Orient Hotels and Generali, and indeed they're not really in a position to do that because it was a decision from a court at the same level, they expressed the view that they thought that case had been wrongly decided and ought perhaps to be overturned by a higher court. So it'll be very interesting to see what attitude the Supreme Court take to that next week. Could we have the next slide, please? So I've covered some of this now. The court decided it was not bound to follow Orient Express, and that in any event they thought it was probably wrongly decided. So the correct counterfactual, in other words, how do you judge the insured's loss of business? You judge it against a world without the COVID-19 epidemic at all, and not simply without the government action which triggered the cover. So in other words, the insured can claim loss of business resulting from the pandemic, starting from whatever date the policy was triggered. And that brings us back to the earlier points I made, that the actual trigger of the policy is not the outbreak of the epidemic. It is either the declaration of the notifiable disease under a disease wording, or it's the government action which forces the closure of businesses if you have a prevention of access type wording. So although the virus had already had an impact on your business prior to that date, the only date from which you can start claiming losses is the date on which the policy is triggered. But once the policy is triggered, then you can claim essentially for all the downturn in business caused by the pandemic, and that's how your loss will be judged. So could we have the next slide, please? So what happens now? Well, following the judgment, the court has made a series of declarations to implement the judgment. They heard further submissions. Not surprisingly, all the parties were given permission to appeal. So the case was considered to be of sufficient importance that it should be allowed to appeal. And although normally the appeal would have been to the Court of Appeal, the view was taken that the procedure, which is called the leapfrog procedure, which allows very, very few cases, but occasional cases of sufficient public importance to leapfrog the Court of Appeal and go straight to the Supreme Court. That was allowed for in this case. And as I've said, the case is now due to go before the Supreme Court next week, a 4-day hearing. And I've little doubt that they will try to deliver a judgment before the end of the year. One of the slight ironies is that apparently one of the judges who is now in the Supreme Court and will be sitting on the panel that hears this appeal next week is the judge who decided the appeal in the Orient Hotels case when that came before the commercial court 10 years ago. Mr. Justice Hamblin, as he then was the trial judge, was the judge on the in the commercial court when that came up, when the Orient Express case came up from the on an appeal from an arbitration award, and he will be one of the judges who will be determining the case in the Supreme Court. So it'll be interesting to see whether he sticks to the view he expressed before, or whether he finds some way of distinguishing that case when he has to look at it in the context of the present situation. Next slide, please. So that's gone one too many, I think. One back, please. Yes. So at some point, and they're not doing it yet because they are awaiting the judgment of the Supreme Court, each insurer will have to publish guidance to its policyholders as to how they're going to adjust individual claims. And as I've said, that won't be entirely straightforward, because it's not a case of saying the insureds have won and the insurers have lost. It will depend on the type of wording that you had as an insured, as to whether you have cover and exactly how that cover should respond to the pandemic. So I'm pretty sure that most insurers, once the final outcome is known, will not seek to be overly restrictive. They will recognize that the courts have found coverage for insurers as far as for insureds as far as the main principles are concerned, but there will nevertheless be insureds who fall one or other side of the line for what they as individually may regard as rather arbitrary reasons. And that's why, of course, this whole saga may trigger legal actions against insurance brokers by disappointed policyholders, because if you're a policyholder who finds yourself with a prevention of access clause in your policy, which turns out not to have been triggered, you may well turn around and say to the broker, well, why didn't you get me one of these wider covers that were clearly available and would have given me cover? So it'll be quite interesting to see whether brokers receive those type of claims and how they respond to them. Many of these insurance policies have arbitration clauses, so it's possible that there will have to be separate arbitrations in relation to some of the policies. I mean, the arbitrations will be guided and bound by the decision of the Supreme Court, but there may nevertheless be arbitrations. And wearing my hat as a regular mediator, I wouldn't be surprised if there are schemes for appointing mediators to deal with disputes between insureds and insurers, given that once the guidance from the Supreme Court has been fully digested. So we've got all that to come. If we could have the next slide, please. And I think sitting here waiting for the Supreme Court, you know, there are still quite a lot of areas of uncertainty that weren't entirely cleared up by the judgment. One of them is the first point I make. Supposing a policyholder closed his business down before the government orders came out, the government new laws came out, because the pandemic was already causing damage, would that be a trend of the business? So would you be able to say as the insurer, well, your business was already suffering a downturn before the trigger of cover, before the government regulation, and we can take into account that downturn to reduce the amount we pay you? I'm not sure insurers are going to take that point, because it sounds rather artificial, and I think would lead to some pretty bad publicity if they took that point widely across their policyholder base. But it's a potential issue, and they some of the counsel who appeared in the hearings after the main judgment, when they were determining what declarations the court were to make, did try to get the judges to clarify this point, but they weren't prepared to do so. Certainly an issue on the appeal is going to be whether the court was right in saying that it's only an actual law or regulation that triggers the policy, because I have to say my own view in the period prior to the judgment was that there was quite a strong argument for saying that when the Prime Minister appeared on everyone's television screens to say, you must stay at home, you must close your business, even though that didn't have the force of law at that moment, people would definitely and did treat that as a legal requirement, because it was something that the government were directing specifically to all of us. So I think there was an argument to say that the trigger for cover should have been that earlier date when those non-binding directions were given by the court. And then this whole issue I mentioned about restaurants and so forth and other businesses which found their business affected but not completely stopped. Where you draw the line between those who get cover and those who don't, again, possibly in quite an arbitrary way, will be quite significant. And finally, after we moved, I know we've moved away from that now onto a national lockdown again, but for a period, of course, we had a series of local lockdowns, and we don't totally know how those will be judged from the point of view of the insurance policies. In some ways, a local lockdown fits more within the way in which the insurers wanted to interpret these policies, i.e., some local event that applied to a specific town, a specific community, or a specific area rather than nationally. So they may find it easier to get cover in areas where local lockdowns applied for whatever period they did. So there are those areas of uncertainty. And if we could then look at the last slide, please. Has it all been worth it? Sometimes with test cases, you end up with as many questions remaining unanswered as you had, or different questions unanswered as you had before, because as we all know, the law likes to work in very precise ways. And if the court is asked to determine specific questions, normally speaking, that's what they do determine, and they don't answer necessarily wider questions or issues that were not specifically put to them. However, I think one would say that this test case has been worth it. I mean, we'll see if the Supreme Court changes things a lot, but broadly speaking, the judgment has been welcome news for many policyholders. Disease and the so-called hybrid wordings do provide pretty clear coverage. Prevention of access wordings may, as we've seen, fall on either side of the line in a potentially quite arbitrary way. So we may not have got as much clarity on that as we would have liked, or certainly not as much what might be considered to be justice. There will inevitably be further delays and uncertainty until the Supreme Court judgment, possibly beyond, but I would expect insurers to scramble quite quickly once the Supreme Court judgment comes out to start adjusting claims, because they've already suffered quite a lot of public relations negativity as a result of the delay, because of course a lot of these are very small businesses that we're talking about, who, although they will have obtained some government support, have nevertheless suffered serious financial losses. And I think from a legal perspective, as an insurance lawyer, the case will, for many years to come, be a very significant precedent for the determination of how business interruption policies should be interpreted. And that's no bad thing, because, as I said at the beginning, it's an area where you are required to use your crystal ball, and where many policies are written in quite archaic language, which hasn't changed for many, many decades. And it has given rise to a lot of, in a way, unnecessary disputes because of a lack of certainty as to what specific terms and phrases in those policies mean. This case has clarified quite a bit of that, and I suspect the Supreme Court will do their best to retain that clarity and even provide some greater clarity. So I think it has been worth it, and I think from the point of view of those who are studying English insurance law, and essentially most, I think, common law jurisdictions are going to respond in a very similar way, we'll see it as an important case. It's not so important from the point of view of the US. There, as I understand it, they are looking much more at whether policies that require damage to property are triggered, and as whether whether you can treat the impact of a pandemic as causing some sort of physical damage, as well as just a financial damage. And there are US precedents that could take you in that direction. So I think there are test cases in various parts of the US going through the system on similar facts, but looking at it in very different ways. But I think certainly the courts in the main common law jurisdictions of Canada, Australia, New Zealand, etc., will look at it in a very similar way. So I think it's been worth it. It's been of great interest, and I hope this briefish summary of the case has been helpful. And if there are any questions now, then I'm more than happy to, questions or observations, I'm more than happy to take those now. Or if everybody feels it's all very clear, then I'm delighted for that as well. So thank you.
Charles, thank you very much for this very insightful presentation, bringing us all up to speed on the FCA test case. Those of you who want to have a look at the Supreme Court proceedings, there's a video link you can join in on Monday, so you're now very well prepared. And I certainly agree with Charles that this case will be with us for a very long time, and will be of great interest to students of insurance law. So in a way, those of you who are taking an exam in January, you're lucky that you're sort of let off the case for now. But certainly next year, this case will be, I'm sure it will be a big feature in my module. So with that, I just gonna stop sharing the screen, because I think this makes it easier. Now, could I, first of all, could you either put on your video and clap, or show your appreciation for Charles with some clapping hands, please?
Oh, that's very kind. Thank you very much.
Okay, well, I had a question, so maybe I'll start, which is, as I understand it, most business interruption policies will be sort of on an annual basis. So now being sort of 8 months into the pandemic and the lockdown, many of them will be coming up for renewal now or very soon. So, Charles, have you seen any changes to the wordings to sort of expressly exclude sort of pandemic type losses, or?
Well, I don't have a lot of information about that, but I did talk just a few days ago to the chief executive of one of the insurers who is involved in this case. I won't say which one, but he said, "Oh yes," he said, "we changed the wording straight away." So they, for people who were renewing, I'm afraid to say, from a pretty early point after the pandemic started, renewals excluded the impact of the pandemic. So, and I suspect going forward, insurers will be quite likely to exclude pandemics in general from these type of coverages. Whether they'll offer some other type of cover which does cover pandemics, I don't know, but I think these type of business interruption policies, they will try to draw back to where they thought they should be in the first place, which is a responding to purely local events. So not all insurers perhaps, but I think that that's quite likely to be a trend.
Okay.
I hope it was fairly clear, and certainly I would say Francisca is absolutely right. I mean, you might not want to sit through 4 days of the debate in the Supreme Court, but it would be really, and I'm going to try and listen to a fair bit of it. It would be really interesting, I think, to listen in to some of it, because it'll give you that great insight into the way in which these very senior judges and lawyers look at these type of issues, and I think it would be very interesting and very helpful to an understanding of this area.
Absolutely. Well then, Charles, thank you so much for today's guest lecture. It's been absolutely wonderful to have you.
Thank you.
And maybe there's going to be a part 2 after the Supreme Court decision.
Yes, I wouldn't be surprised. I wouldn't be surprised at all.
Yeah. All right. Well, thank you very much. And thanks everybody for joining tonight. Thank you.
Thank you very much. Bye-bye.